Today, we're doing a legal case brief on a fascinating recent Madras High Court decision. If you're a law student or, just a total nerd for how administrative rules clash with parent statutes, you are going to love this. The case is v. Ganesamoorthi versus the income tax officer, and it is literally a masterclass in statutory interpretation. To keep things structured, we'll be using the visual IRAC method today. We're going to breeze through the facts, pinpoint the core legal dispute, compare Section 515 with Rule 257, break down the High Court's rationale, and then wrap it all up with the final verdict. Let's get to it. Part 1, the facts of the case. Let's set the stage and see exactly how Mr. V. Ganesamoorthi ended up before the Madras bench. So this timeline perfectly illustrates the factual hiccup here. The petitioner's earliest recorded appearance before the income tax authorities was September 29, 2025. But just a couple of months later, on December 15th, he went ahead and formally filed his application to be registered as an income tax practitioner. The state kicked that application back on May 27, 2026, which led straight to the High Court order disposing of the petition in June. Keep that super tight gap between September and December in the back of your mind. Now, to really grasp the petitioner's argument, we had to look at his inherent eligibility to practice under the Income Tax Act. The Act defines an authorized representative as someone authorized in writing by the assessee to appear on their behalf. Under Section 515, this explicitly includes folks who have the prescribed educational qualifications. And here's the kicker. The state totally admits he has those qualifications. There's zero dispute there. Moving to Part 2, the core legal dispute. This is where things get spicy. We have two very different arguments colliding over those qualifications. The crucial question here is this. Does the state's requirement of a one-year practice period unlawfully restrict a right that the Parent Act already granted? The petitioner is saying, look, I have the required education under Rule 252. Rule 257 demanding a full year of practice before I get a formal certificate, that's an illegal extra condition. But the respondents? They admit he's legally appearing for assessees right now. Their hard line is simply that getting your name officially typed into the formal register inherently requires you to complete that 1 year of practice under the rules. All right, Part 3. Let's actually put Section 515 and Rule 257 head-to-head and see this statutory clash for ourselves. So the ultimate question here is whether a subordinate rule is illegally restricting the parent statute, or just, supplementing it. On one hand, you have Section 515, the heavy-hitting parent statute that grants the broad eligibility to act as an authorized representative based on education. But then you've got Rule 257, the subordinate rule acting as the gatekeeper. It explicitly demands a year of practice before handing over that formal certificate of registration. It kind of looks like a total contradiction, right? How are you eligible to practice but denied the certificate to practice? Part 4, the High Court's rationale. Let's dig into the judicial analysis and see how Justice D. Bharatha Chakravarthi untangled this mess. The judge's phrasing here is just spot on. He stated that the rules in the statute are not enemies. They just do different jobs. He said the rules, quote, operate in a different field and supplement the statutory scheme. Basically, they aren't trying to rewrite the parent statute. They are just laying out the administrative housekeeping instructions for maintaining a formal register. Let's track the court's logic step by step using harmonious construction. Step 1. Section 515 grants the foundational right to appear. Step 2, and this is absolutely crucial, the petitioner is actively exercising that right. The state isn't actually stopping him from walking into a room and representing clients. Step 3, Rules 255 through 257 purely govern an administrative list. Therefore, Step 4, the court concludes that the 1-year waitlist condition does absolutely nothing to dilute the rights granted in Section 515. They exist in perfect harmony. Eligibility to act is just completely separate from maintenance of a register. Which brings us to Part 5, the final verdict. Let's look at how the court wrapped this up and what you really need to take away from it. So, relying on that harmonious construction, the court found absolutely no illegality in the state returning the application. They disposed of the writ petition, but, and here's the silver lining, granted the petitioner liberty to apply fresh after October 1st, 2026. Remember our timeline? His first appearance was September 2025. When he applied in December, his 1-year clock simply hadn't run out yet. The court basically said the state was right to hand back your paperwork, but hey, just try again once you actually hit that 1-year mark. Now, for you law students, here are the essential takeaways. First, this is a textbook, beautiful application of harmonious construction. It proves that subordinate legislation can prescribe administrative conditions without automatically being repugnant to the parent act. But look at that last point. This is the critical omission. The judge explicitly noted that the petitioner never actually challenged the vires, the underlying constitutional or statutory validity of Rule 257 itself. He only complained about how the rule was applied to him. And that leaves us with a really provocative question. What if the lawyer had walked into court and attacked the vires of Rule 257 directly? If he argued the rule itself was an unconstitutional overreach of power, would the court's analysis on repugnancy have been totally different? Would Justice Chakravarti have been forced into a different outcome? It's a massive reminder that the specific question you ask the court entirely dictates the answer you get. Think about that next time you're drafting. Thanks for joining me for this explainer, and I hope this helps you build tighter, more strategic legal arguments.